Last wills and testaments in the Philippines. How do people inherit property in the Philippines? There are three different ways of coming into an inheritance. Inheritance can be testate, intestate, or mixed. Inheritance is testate if it occurs through a valid will. Inheritance is intestate if it is not through a will. Inheritance is mixed if only part of the property has been disposed of in a will. In this case, the rules of legal or intestate succession shall be applied to those properties not disposed of. How is the property divided if there is no will? In the absence of a will, the law allots inheritance among nearest relatives of the deceased, including, of course, the surviving spouse. In the absence of all these relatives, the estate goes to the government and to the state. The shares of these legal heirs are allotted by default according to the portions set by the Civil Code of the Philippines. What is a last will and testament? A will is an act by which a person is permitted, after following the formalities prescribed by law, to control to a certain degree the disposition of this estate, to take effect after his death. In the Philippines, a valid will must always be in written form. The will must be either signed and witnessed before a notary, or be entirely handwritten and signed by the testator. A valid will has several conditions, because testate inheritance is not considered a natural right. Rather, it is a right granted by law. For this reason, the exercise of this right is subject to the conditions set by law. One of those conditions is that the will must be probated for it to have legal effect. What is probate? Probate is a court proceeding to establish the validity of the will. Before any will can have force or effect, it must be probated in court. To probate a will means to prove to the court that the document offered really is the last will and testament of the testator. The presentation of the will for probate is mandatory and is a matter of public policy. It must be proven that the will was executed, attested, and has been published as required by law, and that the testator was of a sound and disposing mind. Can a will be the basis for transferring ownership of property before probate? No. Until admitted to probate, a will has no effect whatever, and no right can be claimed under it. No will shall pass either real or personal property unless it is first proved and allowed in accordance with the rules of court. How is probate initiated? A petition for probate should be filed with the regional trial court. If the deceased was an inhabitant of the Philippines at the time of his death, it should be the RTC of the city or province where he resided at the time of death. If the deceased was an inhabitant of a foreign country, the RTC of any city or province in which he had assets or estate can be filed with. A petition for probate filed with the court must show, so far as known to the petitioner, the jurisdictional facts, the names, ages, and residences of the heirs, legatees, and devisees of the testator or decedent, the probable value and character of the property of the estate, the name of the person for whom letters of administration or letters testamentary are prayed. If the will has not been delivered to the court, you should also state the name of the person having custody of it. The court shall calendar the probate for hearing so that all concerned may appear to contest the allowance of the will if they so wish. Notice of the time and place of the hearing will be published in a local newspaper for 3 weeks prior to the hearing date. But no newspaper publication need be made where the petition for probate has been filed by the testator himself while still alive. The court shall also cause copies of the notice of the hearing to be sent to the designated or other known heirs at least 20 days before the hearing. Personal service of the copies of the notice at least 10 days before the hearing shall be equivalent to the mailing. but this notice shall not be required except to compulsory heirs if the testator filed for the probate of his own will. What are the grounds for disallowing a will? The will shall be disallowed if not executed and attested as required by law, if the testator was mentally incapable to make a will at the time of its execution, if it was executed under duress or the influence of fear or threats, if it was procured by undue and improper pressure and influence on the part of the beneficiary or of some other person for his benefit, if the signature of the testator was procured by fraud or trick and he did not intend that the instrument should be his will at the time he signed it. Can a foreign will be given effect in the Philippines? A foreign will can be given legal effect here. This requires proving in court that the will was made in accordance with the formalities and law of the place where the testator resided or those of his country. Additionally, a foreign will can be directly submitted for probate in a Philippine court. It does not need to first be probated in the foreign country. Does a last will and testament executed abroad need to be first proved at the foreign court before it can be given effect in the Philippines?
No, it need not be. A foreign will can have effect in the Philippines, and it can be submitted directly to a Philippine court for probate. Otherwise, if the instituted heirs do not have the means to go abroad for the probate of the will, it is as good as depriving them outright of their inheritance, since our law requires that no will shall pass either real or personal property unless the will has been proved and allowed by the proper court. However, the foreign probate of a will can also be given recognition and effect in the Philippines. This is called reprobate. In reprobate, the local court acknowledges as binding the findings of the foreign probate court, provided its jurisdiction over the matter can be established.
Which country's law will govern the estate of a deceased foreigner? What if a foreigner dies, leaving property in the Philippines? The foreign citizen's national law governs both intestate and testate succession. This is with respect to the order of succession and also as to the amount of successional rights, as well as the intrinsic validity of the testamentary provisions. This means that who gets to inherit, in what order, and how much, as well as the legality of the provisions of the will, are all referred by the Philippine court to the national law of the foreigner. The estate of the foreign decedent or testator will be governed by his national law. For this reason, dissatisfied heirs of a foreign citizen generally cannot assail a will or its provisions for being violative of Philippine law. The Philippine system of legatine, the legatine is that part of the estate which the law reserves to certain heirs, was not intended by Congress to extend to the succession of foreign nationals. Which court will give effect to or enforce the foreign law in the Philippines? This is where it gets tricky. It is still a Philippine court which has to rule on these issues, even though foreign laws on inheritance will be referred to. But a Philippine court cannot be expected to know the foreign laws. For this reason, the foreign law in question will need to be properly submitted in evidence at the Philippine court case. Otherwise, it cannot be given effect. Proving a foreign law for purposes of enforcement by a Philippine court in accordance with Philippine rules of evidence can be an arcane process which requires the lawyer to be versed in its particular complications. Thank you for watching. For more videos, you can watch us on this channel. For more content and online consultations, you can find us on lawyerphilippines.org.